Good evening. I'm Dr. Basil Considine. I'm here from the ACU Online Writing Center, and we are kicking off this semester by looking at how to cite court cases. Now, court cases have been in the national news and the regional news for many reasons. They're kind of a perpetual favorite for newspaper coverage because these are things can have significant ramifications for people's daily experiences and lived lives. They usually don't show up in the paper because something is very obscure, but because the ramifications of a legal decision have far-reaching implications. And so it's no surprise that court decisions are a very commonly cited element in papers that involve legal regulations, that involve determinations of liability, and other things that affect fields like counseling, like healthcare, like education. And so today we're going to talk about how to cite a court case in APA style. And we'll be using a specific example from one of our higher education in courses. So if you are new to the Online Writing Center, we work with students at any stage in your writing. You can work with us through a variety of channels. You can come to webinars like this. You can schedule appointments with us. You can send quick, concise questions to us via email. And students will do everything from bouncing ideas off as they're brainstorming and thinking about how to organize or focus a paper, to sending partial or complete drafts in for feedback, to coming to us with dissertation chapters or fractions or a whole completed proposal or manuscript that they're looking to get another set of eyes on before they submit it. And all of those are fine. All of our services are completely free to students. So please do not worry about how we might judge you or how we might charge you, because we're not going to do either of those two. You can sign up for appointments through us online. You'd start by going to my.acu.edu, and then on the resources or links drop down, you'd select the quick link for the Online Writing Center and just follow the instructions from there. You can sign up for 3 different types of appointments. You can sign up for asynchronous appointments where you upload a copy of your paper and a special request for feedback. We look at it and then we send you feedback via email. And then the other 2 are different flavors of real-time appointments, meaning you'd be in conversation with us. Some people prefer to focus on the words being said and asking questions, and so they'll select a phone appointment. Other people will prefer Zoom because they like to see the screen and see how things look in real time, or perhaps they're asking questions about how to format something, all of which are fair game. We're happy to help with them. If it's something where it's just a quick question like, oh, how do I do the citation? Have I correctly cited this source, or I can't find this info, what do I do? You can send that to us via email to onlinewritingcenter@acu.edu. We field lots of those questions every day. Not a problem. You don't need to sign up for an appointment for that. But if you're interested in more extensive feedback, by all means, sign up for an appointment. If you're not sure, you can always email us and we'll let you know if it's more of an appointment scope thing or not. The basic set of events is that you sign up for the appointment. You will, by the time your appointment rolls around, send us your paper by uploading it to Canvas/Turnitin. And then for a asynchronous appointment, we'll send you feedback, generally within 24 hours, a little bit longer on a holiday weekend. And if it's a real-time appointment, you'll get your feedback right then and there. Now, I do want to let you know that we have a lot of webinars, but if you scroll down past the schedule, you'll see that we have this tabbed guide. So for example, if I wanted to see all the HIED courses, I just click on that tab and it would bring up that list sorted by course number and then sequentially. So if we have something in week 1 for the course, it'll be at the top, and then week 7 will be at the bottom of the listing for that course. You'll see me using our APA course paper template later. We have a YouTube channel for watching videos on the go, and we also have a blog. So here's what we're going to be talking about today. First, we're going to be talking about how to cite court cases in APA 7th edition. Then we'll look at an assignment that'll ask you to not only cite, but to discuss, to analyze, to pull out different pieces of details. And then we'll finish with talking about how that will look when you're actually writing that paper, to just give you an idea of the outlining and drafting. So let's talk about how to cite court cases in APA 7th edition. I'm going to start by saying that there are guidelines. You won't find these listed on the APA style website. This is one of the things they'd love you to buy the manual for. And if you're doing a lot of this, if you are working in a legal field where you publish an APA or you're a counsel for a organization that is publishing an APA, you probably will want to buy it because it does have some very detailed and specific examples that make looking up that exact thing very easy. But these are found primarily on pages 357 to 361 of the 7th edition APA manual. And you'll find that they, for court decisions, have a set of information that you need. One is the title or name of the case. And even if you haven't cited one of these before, you've probably seen this sort of citation before. So, for example, Plessy versus Ferguson or Brown versus the Board of Education. That will be the title or name of the case. It is usually one party versus the other, the defendant and the aggrieved party, if you will. And so by listing the two different parties in there, which, the parties that are having the dispute there, Brown versus the Board of Education. Brown was suing the Board of Education over something. And then besides that, we want to know, well, where can we find more information about this? And this is where there's a little bit of variation because just like with the Christian and Hebrew Bibles and the Quran, where there are internationally standard ways of dividing up what is what, in a similar fashion, there are authoritative sources for different court decisions. So the U.S. Supreme Court, for example, will publish an official set of court decisions that come in the U.S. reports series. And, state courts will have their own series, local ones, some other way that they are making that information available. And they can also be reported in other things. And sometimes they are reported before the official finalized version comes out, or they might be reported online before the printed version is out. So there is some variability depending on that. If you are going to be citing this, normally you would go with the United States reports. But for example, I can think of a couple cases where the New York Times and the Washington Post published the decision before it was officially available through the United States reports, but they had received a copy from the court itself. So that would be one of those occasions where you're citing a different source. And that's usually because something is so well known and so well cited that other people have made it available, or because it is hot breaking news of the precise jurisdiction of the court. That would be, for example, the U.S. Supreme Court has jurisdiction of the United States, the federal level. If it's a state court, we have different levels like state Supreme Court, might be a state appellate court, might be a state trial court, and generally you would be going for the final decision unless you're specifically discussing some details of a decision leading up to the final one. And the normal course is that it'll rise up to, so it might go from a local court to a state trial court to a state appellate court to a state Supreme Court. But once it goes to the U.S. Supreme Court, there's no higher authority in legal terms. So you'd usually be referencing the final one, which will itself make reference in summary to the ones before it. So that's the precise jurisdiction of the court. The date of the decision, in this case, we're just talking the year here. And then if there is a URL available, include that. Is it required? No. But in general, there has been a strong push in the last 20 years to make court decisions available online. And so you will often, not always, but often be able to find that. And it's a handy thing both for yourself and for any readers to be able to reference the whole thing. Now, a quick note, with the published cases, so just because of the length of these and the facts of the print industry at the time, you will find in many older compilations of court cases won't have individual page numbers, or it might be something that's available online, but the page numbers have not been assigned yet. And so for that reason, you might not have a page number assigned to the case, or might not have it assigned yet, in which case you just use the underscore symbol 3 times in place of the page number. So for example, there's a couple cases in front of the Supreme Court right now. If they rule on it in the month of May, then it will probably not have that page range initially assigned because there's sometimes a little bit of editing or transformation as it's fit into that publication form. And so it might be assigned that once that becomes finalized. Oh, I should say that in the realm of federal decisions, there's a similar hierarchy to state courts. So you have the U.S. District Courts, followed by the U.S. Circuit Courts, and then the U.S. Supreme Court at the top. And how one jumps to the next level, those decisions is sometimes a little less linear because something might get sent back to another court level for jurisdiction, and then that gets appealed to the next level above it. And they might appeal to another party that's several ranks higher that declines to take the case or accept it. So we usually want to go to the latest, greatest, so to speak, because that obviates a lot of the confusion. So in terms of citing it, what would this look like? Well, I mentioned Plessy versus Ferguson, Brown versus Board of Education. It is really that simple. Name, the period, name, and then the year. And if it's a parenthetical citation, same thing. So for example, in 1982, the US Supreme Court ruled that states cannot constitutionally deny students access to a free public education on account of their immigration status. How do I know that? Tyler versus Doe, 1982. All right. So if you want to drill down a little bit on those different requirements, we have from the AP manual on the left side, we have the state court template. And then on the right, we have the federal. And because the federal publications system is somewhat standardized more than the states, you'll see that there's this very slight difference where we have in the state, it says volume reporter page and then court year. And then in the federal, look, we see that we have the slightly different standards for the Supreme Court, for the Circuit Court, and for the district courts. But it's really just small variations in the reference, and the parenthetical citations are just name versus name and year. So with that in mind, let's take a look at HIED 642's week 1 or assignment. This is the LexisNexis Problem Solving assignment. So this is coming from the Legal and Ethical Issues in Higher Education course. And if we look at it, it starts pretty straightforward. Use LexisNexis to locate some cases and answer the questions about them. Now, we have here two cases that have some relevance to Texas. One of them is something involving a university in the Dallas-Fort Worth area. And of course, ACU Online is our ACU Dallas campus. So that's a neighbor institution to us. And then we have a case involving Loyola University of New Orleans, one state over in Louisiana. Now, you can look these up on your own. For my demonstration purposes, I'm going to look up some other courses because a lot of the questions involve looking for specific information, and you want to do that yourself for this assignment. But we'll show you the process. If you would like to follow along using LexisNexis, you can go to the ACU Online library site and pull up that. We'll show that in a moment, and follow along, putting in the cases that you're interested in and pulling the details that you want. But I'm going to do some other examples other than these two that are listed here. So we have a bunch of questions. So the first is just go ahead and use this thing and find out if this is classified as good law. And the question is immediately, what's bad law? Well, something that's overturned is considered by the court overturning it to be bad law. And there are also some cases that in the history of our court system, we look back and say, that was not great. So there are a variety of criteria for that. But the Shepardized function is a very handy one to do because even a lawyer is not expected to know all of these things. There are some very important cases that you study as part of law school, but a lawyer is usually working as part of a team. There might be a paralegal who is doing background research, who is helping prepare reports, who is presenting stuff. You might have multiple attorneys is preparing things for the litigator. There's a lot of looking at different information, trying to find out, is this the most current? Has this been superseded? Is this relevant? And so the shepherdized function is one of those pertinent things. The second question is asking to identify just the type of court and what its jurisdiction is. Third is the type of institution or institutions involved. If we look at this here, just by the names, Texas Christian University is a religiously affiliated and private university. Loyola University, same thing. We have one that is leaning in a more evangelical direction and another that is leaning in a more Catholic direction. And that has a number of different shadings. So for example, I'm an alum of the University of San Diego. Now, the University of San Diego happens to be a private Catholic university, but it's not affiliated with the religious order. Now, usually if a university has Loyola in the name, it is a Jesuit institution because it's named after one of the key figures in the early history of the Jesuit order. So there may be particular details that you find important to include besides the general public, private, religious, which is very important when it has to do with governance, when it has to do with who owns what, who has liability. Identify the other party. So this is the party that is usually the one that's being sued. One sentence summary of the facts. The other party is not always the institution because you might have an individual, but summary of the facts. Okay, what's going on? This is, can you, in, we'll say roughly 3 lines or fewer, can you give us a good idea of what's going on in the case? What type of claims were asserted, in this case against the universities? Oh, what is the thing the court is trying to decide? What was the result? What was the basis for that decision? And then if the plaintiff wanted to appeal the court's decision, in what court should that appeal be filed? So if it's a Supreme Court decision, then generally you're out of luck, except for the court of public opinion, which is a whole other thing and has no jurisdiction, or trying to change the underlying law or constitution involved. And there have certainly been cases where people have done that. I don't believe for these specific examples listed in the assignment because they're relatively recent as court things go. But if we look at the assignment, it's a pretty straightforward thing. We see, okay, have you done all the things asked for both court cases? And then has your reflection been, let's see, 300 words. So a rule of thumb is roughly 250 words, double space times New Roman font, 1-inch margins. Basically, if you're using our APA course paper template, 250 words is going to be around 1 page. So we're looking at something that's kind of in the 1.25 to 2 page range as your target guideline. You can go a little longer, but don't go under. And is your summary clear, concise, and organized? All right. So with no further ado, we're going to do 2 things. And I'm going to recommend that if you don't have a copy already, that you grab a copy of our APA course paper template by clicking on that link. Now, if you click on that link, you will get a link to a Google Drive share, and you can download various templates that we have. Let me go ahead and share my screen so you can see that. And so in this case, we have some specialized examples for different things like writing a dissertation or a DMP project, but we just want a course paper template here. So I'm going to go ahead and I'm going to download that. And then I will just save that on my computer and we'll come back to that very shortly. All right, now our next step is we're going to go ahead and open LexisNexis. Now, in LexisNexis, you'll see here, if we open that link in the assignment, it'll say, oh, yes, you can go to the Library Distance Education portal and select LexisNexis Universe. So if we open that, scroll down alphabetically, it's right here. And it'll ask you to log in. And we have various things we can use for a guided search, or we can just start searching here. Now, let's just quickly go through the process of how to search for a course. So if you have that information, let's go ahead and grab the Boyd versus Texas University. If I take this and I just search that, we're not going to get anything because it says here, no documents found in news filtered by previous 2 years. So I get this question a fair bit from people who don't notice that the search bar defaults to previous 2 years here. Now, if we change to cases, then we have that option to migrate through that, but we want to do a search here. So we'll start with the search. You can change this to all available dates, and you can set this to that if you want, but that's not going to be super relevant here. What we're interested in is when we get this, we want to go to cases. Now, here we're not, there's something a little counterintuitive here, because on this previous screen, it looked like there were 11 here. Now, if I go ahead, we seem to be running into a problem with, we have some search things that are throwing us off. So what I recommend people do right away is to go ahead and just start with the 2 parties. And you'll see that we immediately, when we search for that, we have a different set of results. Now let's see what happens here. There's our court case here that we're interested in. Now, we can go ahead and click on this. And we see the decision. We see that was delivered 1999. I can go ahead and even paste that same thing up here and check. Yeah, 1999. That's what we're looking for in Fort Worth. And this Texas APP, that's the Court of Appeals of Texas that you see here. So we found the court case that we were looking for. And we can even see that there's this note here that someone requested a rehearing. That's usually when you claim that the judges didn't take something into account that they should, or that there's been a new discovery of evidence or something like that. And so we can look at this and see, okay, this was the decision. All right, now just for the sake of how to find it, let's go ahead and we'll grab the other one, Roe versus Loyola. Now, if we started with just the citation in, and I will say the citation in APA format, that actually in this case brought it up right away. So sometimes that'll work out for you if you're searching in the right places. Other times you'll have to take out some information. And it's also a good idea to just take a look at that because sometimes you'll see that there being multiple suits involving the parties. In this case, we're going to go look at cases in the United States. And sometimes you'll see that there have been other things involving this. In this case, there are lots of people named Roe. So we're not going to worry about that further here. But if you are going to be exploring this case here, bring it up, take a look, and you can see we have the jurisdiction, the dates. All right. Now, I have something I like to do because I have a doppelganger of sorts, someone who has the same name as myself. So I think it's fun to see what they've done. And now, in this case, if I go ahead and search for court cases involving someone named Basil Considine, we find 2 people here. I believe this is actually father and son here. But for the sake of our demonstration here, we're going to go ahead and look at this one here. And we have here a court case. We've got the plaintiffs and the defendants. We have the court. We have when it was decided. We have a docket number even. We've got the official record of what this course is recorded as. And so we could start going ahead and reading through this. Now, if we go ahead and look back at our assignment instructions, we have a list of different things to be asking. So we have determine if the case is good law using the Shepherdized function, identify the court, identify the type of institution involved, the other party. So let's take a look at this here. So we're looking for that Shepherdized function. And you can see that we have shepherds here, no subsequent history, and then it's been cited a lot, neutral, positive, caution. Let's see what that caution is. And so it brings us to two other things. Now, this one says it was distinguishable from that case. And this one says, oh, Platon's reliance on that was misplaced, saying it was not relevant to that particular discussion. So, although there's that caution label, it is telling us, okay, well, don't use this as a blanket thing, but it's not telling us the case was bad. But let's go ahead and click on that Shepherdized this document and see what that comes up. And so this goes ahead and it looks at this, and we see cited in the dissenting opinion for several things. We look, and then the positive. So, cited in the dissenting opinion means that someone who is writing the opposing things, well, I disagree about the ultimate decision, common thing in court cases with the panel of judges. They were disagreeing on it. So now, how much has this been used? Well, it's actually been cited by 20 cases since then. So it has clearly been getting used and being referred to stuff. And I'll let you do the final step in determining whether this is good or bad. All right, let's take a look at our instructions again. I'll go ahead and open this up in the web browser here for convenience. So we have provided one sentence summary of the facts. And so this will take some reading. But I think if we looked at this, this is summarizing many of the key details that one party and their spouse filed a complaint against the hospital and a doctor saying that their radiation therapy was not done in a proper manner. And with that, there was a decision and by a arbitration panel that the parties disagreed with, and then things happened. So you can summarize that into one sentence after reading it. In our case, let's go ahead and look at the next question. What type of claims were asserted? So in this case, the claim is that there was a claim of malpractice, but also that the arbitration agreement was not written appropriately or not in a manner to cover what the hospital and the doctor said it was. We have what is the issue that the court is trying to decide. So there's a lot of background information, but what exactly were they trying to decide? You can look at the outcome and see, okay, they split it up. They said, okay, you can use the arbitration process for one suit against the party, against the hospital, but you couldn't do that for the doctor. Now, that is something where when you're looking at what they're trying to decide, you can work backwards from that and say, okay, they were trying to determine whether the arbitration agreement was binding for the two different parties, and they agreed yes on one, no on the other. What is the result and why? We kind of covered that, and they were referring back to the wording. And if the plaintiff wanted to appeal a court's decision, what should that be filed in? Well, this is where we go back to looking at what level this was at, and to some extent, LexisNexis will give you some suggestions down here. So they'll tell you about the appellate courts of Michigan and their jurisdiction and other things like that. So if you're not understanding what all the different parties being named, then you can certainly do a little research below. All right, so let's take a look at the parties here. So this was a decision by the Court of Appeals of Michigan. Now, the Court of Appeals of Michigan, that would be at that state appellate level. And we can see that they worked their way up. They started in the Wayne County Circuit Court. And if you're curious, you can do a quick search for that and see what is that. So that is the Third Judicial Circuit of Michigan. So that's one of the lower levels of the court system. And when the one of the parties was not satisfied with the decision, they appealed to the state appellate court. And we can see that, at least as far as what we see here, that there's no record here of this having been appealed further. So, oh, also that disposition, that's a nice quick thing to look at. What was the court deciding and what did they do? It's a more terse than you'd want, but you can use this to work backwards and say, okay, affirmed in part and reversed in part. So that means they're looking at a decision by an earlier court level and determining whether that was correct or not. And in this case, we see they affirmed in part and reversed in part. All right, so let's take a look now at our template here. And a good starting point, especially for an assignment like this, where you're asked to have a list of responses here, is to just copy and paste this so you're working off the exact prompt, and then you can delete these later to give your more focused list. So with that in mind, let's go ahead and grab that APA course paper template and take a look. Now you can go ahead and fill in these details later with your name and the title and everything. For our purposes, I'm just going to go ahead and delete this placeholder. And I'm going to start with mentioning the course. I'm sorry, the court case. So I'm going to go ahead and grab that. And I'm going to work that into my response. Now I'm going to italicize that name, Brown versus Considine. That's going to be 1981. Now you'll pass your own judgment here. And we'll want the court here, Court of Appeals of Michigan. It's a state court. And now you can see that you could break this up here and then form it into a paragraph later. Nothing wrong with that. It's a good way to keep track of it. And let's start with the plaintiffs. And we have the question of Harper Grace Hospitals. That is, right now, it is part of a public hospital system. Sometimes these hospitals will merge or change and go through different ownership. So let's just take a look at what Harper Grace is. And if we look at that for the city of Detroit, we'll find that It is a old teaching hospital. And it is affiliated with the Wayne University School of Medicine. Lots of Michigan doctors come from there. So we're going to classify this for our purposes as a private hospital in the sense that it is not like only a private group can go there, but in that it has private funding versus being, say, something that is directly funded by the state or the city or something like that. Now, there's these sometimes little tricky delineations here, but it is both a community hospital and there's private institutions set up to support it, and different parts are funded in different ways. So we're going to look at this and see, okay, well, let's go ahead and move that down there. And here we'll have Harper Grace Hospitals is a part of a public-private partnership. All right, now one sentence summary of the facts. The plaintiff sued the hospital and a physician, alleging malpractice in cancer treatments, and later or appealed, and later sued regarding a binding arbitration agreement. Now, in this case, is I'm answering for this other thing, so we're just going to use the hospital instead. But in the two things for the assignment, you'd of course be looking at universities. Now, one of the reasons I'm saying both of these things was that to have standing, you generally need to have a cause. And so what brings you up there and then leads you to have an ability to dispute, in this case, a binding arbitration agreement. And so the issue the court was trying to decide is whether or not the binding arbitration agreement was valid for the hospital and whether or not it was valid for the physician. Now, these are two separate things, and we know that in part because they had a split decision that one was valid, it was valid for them, but not for the other. And the result? Sorry, that's ruled against the plaintiff, but they ruled for the plaintiffs. All right. Now, in this case, we have earlier looked at the circuit court. So this is, again, going back to LexisNexis. We see that this is Court of Appeals of Michigan. So, this is a different state than you're probably located in. And so the question would be, who would you appeal further than that? And we can see that here, this is listed as First District Court of Appeals. All right. Now for Michigan and Michigan State Legal System Court of Appeals, we can take a look and see, all right, the Michigan Court of Appeals is the intermediate appellate. Okay. So if we look at this, we can see that's the intermediate. Go to their state website and see, we have trial courts, appellate court, Supreme Court. So that is where they would appeal if they were going further. Now, a court doesn't have to take up the case. They can decline, they can affirm, and they can send it back for modification. There are a variety of decisions there. But you can see that by looking through this, we're able to identify things in fairly short order, thanks to the details that are presented at the start, and that we don't have to read the complete court decision to arrive at the understanding there. So let's go ahead and just recap what we've done so far. So we looked at how to cite court cases in APA 7th edition. We talked about the specific example assignment and how to find the discrete pieces of information that asks you to, and then talked about how to start planning out organizing that information on your paper. So the last step here, and let's just briefly review the citations before we go further, that we want to have the reference info, title or name of the case, the citation where it's published or recorded, the precise jurisdiction of the court, date of the decision, and the URL. So let's go ahead and grab that. So if we are looking in our web browser, this information, so we have the record of who the parties were, and we also have this export citation button. So let's take a look at that and see what that gives us, what formats it will allow. Now, this is going to be an algorithmically generated thing, and with algorithms, they're never perfect across the board. There may be things that aren't quite formatted correctly. Sometimes it just doesn't work because it's working with an integrated system and some element isn't working, like you see here. So while it can be a time saver, knowing how to do these in your document yourself is really helpful. So if we go here, I'm going to remove these placeholders. And the first thing that you have here is going to be the different parties. And that's going to be Brown versus Constantine. And then we have the record for that, which is 108 Michigan Appeals Court 504. And then we have the year, that's going to be a 1981. And then how can you access or link to that? Now that's something where if you're using LexisNexis, there might be a way to link the results, but we're actually not interested in LexisNexis. We are interested in the place that anyone can click and access that. So if you are looking for things online, you can see, is this court case, is it actually published online? And that's something that you can do a quick Google search to identify. So if you see here, I just did a search for the case essentials there, and we see, oh, it's available on this website, casetext.com. And that is a perfectly valid thing for us to use because available to the public. And you can see that there's a whole text there. So this is kind of a public recorder website sort of thing. So we can go ahead and include a link for this in our document. And there we have it. We have a example here of how to cite this in the body of the text. We have a complete corresponding reference entry here. And, you would change this into paragraph by deleting these prompts and then seeing if you need to add any other additional sentences, perhaps a reflection on the case. But let's just take a look and see what happens if we remove the outline elements and see how this flows. Because this assignment did have a very good set of questions that followed in a nice logical fashion. And I'm curious to see how this will flow if we just remove the questions and read through the answers. And we see, according to LexisNexis Shepherdized function, Brown versus Considine is a mixed law, is a mixed decision because it has two cautions and is frequently cited by dissenting opinions. The court in this case was the Court of Appeals of Michigan, which is a state court. Harper Grace Hospitals, which is one of the defendants. Is part of a public-private partnership serving as a community hospital with both public and private elements. The plaintiff appellants, Bernice and William and Brown, as well as one of the co-defendants, Dr. Basil Considine. You're just starting we're looking at a course that happens to, a case that it happens to involve a person who shares my name, which we looked up at LexisNexis. So we see we're adding some small details as we go through to transform the answering the prompts into something that flows as a paragraph, but most of the information is there already. By the way, in APA style, you won't normally hyphenate the prefix co. The plaintiff sued the hospital and the physician, alleging malpractice in cancer treatments, and later sued regarding a binding arbitration agreement. And now here we have a slight change in focus from background to what was the court doing. The court was tasked with determining whether. So because I had answered the prompt very directly, I had to add just a little bit of text to make that flow as a paragraph of sentence, but not a lot. The court was tasked with determining whether or not the binding agreement was valid for the hospital and whether or not it was valid for the physician. The court ruled against the plaintiffs in one aspect, stating this. However, they ruled for the plaintiffs in the second. And then if we look at all of this, just from answering the prompts, just from going through and adding this little bit of connecting text, we have here 225 words. So if you do this for both of the court cases, you will end up with pretty much the whole length that's required for this assignment. So start with doing exactly what the assignment asks you to do, and then see if there's anything else you need to complete all the requirements, because this is designed to produce something more or less exactly in the target length. If you have something that's significantly shorter, you might look at how you should expand your responses, but it'll be pretty straightforward. All right, well, I hope that is helpful. We are going to wrap this up because it is, after all, week 0, and we want to start the new semester as well rested and ready for everything as possible. But if you have any questions, please feel free to email us at onlinewritingcenter@acu.edu to schedule an appointment through my.acu.edu, going to the quick links and selecting from that list of resources, the Online Writing Center, and following instructions, or you can visit us online. With that, have a good day.